SJC-12748, Masha M. Shak v. Ronnie Shak.
Good morning. My name is Richard Novich, and with me,
Wait 1 second, we're still learning who you are. The clock hasn't started,
I think I did that the last time I was here as well.
right? There are worse mistakes to make than that. All right, now you may proceed.
Thank you. Good morning. My name is Richard Novich, and with me are Gary Todd and Juliana Zane. Together, we represent the appellant, Masha Shak. The freedom of speech guaranteed by the First Amendment of the U.S. Constitution and Article 16 of the Massachusetts Declaration of Rights is not absolute. This case presents this court with the opportunity to provide guidance and sketch the standard under which trial court judges can restrain speech of parents when necessary to protect and safeguard the interests of children.
Can I ask you a question? What is it you want us to do here? Is it, the judge has reported 2 questions.
Yes, Judge.
And he's also made these amended orders. Do you want us to review the orders as well as answer the questions? What is it you want us to do? Why is this here?
It's here to answer the 2 reported questions, but I think in a larger context to determine the validity and the constitutionality of the further orders.
Of these orders, you want us to, you want us to apply whatever we do to this case?
Yes, Your Honor.
Okay.
To issue a blanket prohibition on all non-disparagement orders, such as the one that is before the court today, would erode the ability of trial court judges to protect children, and I suggest should be avoided. There is certain speech that a child's ears should never hear. A bell rung cannot be unrung.
But tell me then how it is that the first order does that. I mean, it has nothing to do with the child, it seems to me. It has everything to do with third parties. The second, I think, is a closer question, because the second one, I think, does deal with the things within 100 feet of the child. But I mean, how does the first one do that? I don't understand that.
Well, as far as the use of the internet, Judge, the internet, as we all know, does not have a delete button. And as soon as someone posts something online, you lose control. The poster loses the ability to control, to modify it, to restrain it, to pull it back. It's impossible to make any modifications or changes once something has been posted online. The internet is ubiquitous. Anything that has been posted on there, as the court that I've cited in my brief, Nash versus Nash, the Arizona Supreme Court, concluded anything posted online can get to a child in very short order. So the functional result of posting online in this instance, which I...
Although this child's 3 years old, right?
Your Honor, the child is 2, but...
Yeah, 2 years
fair
old.
point.
So doesn't that matter too?
I would say it shouldn't matter, because anything that's posted is forever.
But how is that different from having posters? You know, like, let's go to the days of my youth, whether it was before the social media. Could a judge have said, as a prior restraint, don't give out posters, those posters could live forever. Don't give out posters to the same people that the father posted to on social media here. Don't say those things. I don't want you saying those things to third parties.
Well,
that would be a prior restraint where we'd say that would be okay?
Well, if I understand Your Honor's question right, the posters back in the day when there wasn't an internet...
Print, you know, like print.
Then I think there would be...
The editor that actually looked like letters to the editor.
There'd be a harder argument to say that posting, using Your Honor's example, would get back or could get back to the child in short order. And it's also, I think, would be more...
Well, not in short order. The child can't read yet.
Yes, but the child will ultimately be able to read at some point down the road.
Yeah, because the mother or somebody else at the synagogue will have kept the posters.
And that would lose the person who put that up would lose the ability to rescind it or control that.
Right, so it's the same result, you're saying?
I think it may have the same result, but those aren't the facts here.
I understand that. I'm just saying, but you're not just asking us to do the facts here. You're asking us to give guidance.
I am asking you to give guidance insofar as the internet is concerned and insofar as speech, that the child is present to hear or is in close proximity to...
But that's not what the order is. I mean, you used the word could.
Yes.
That's scary. You know, the First Amendment's not always pretty, but it's precious. And could's a little scary. How about would likely to reach the child and cause harm?
Let me try to reframe that, if I could, just for a moment, because Your Honor's point is a fair one. If a parent were to strike a child with a stick and the injury didn't cause the striking didn't cause a visible harm, is it still abuse? The answer to that question, we can all agree in this room, of course it is. Harm is not any different if it's caused by words, you can't see it. If we could prevent someone from being hit with a stick, I have no doubt that everyone in this room would do it. That's exactly what the object of the trial court judge's order here was. The object was to prevent harm that could happen into the future.
Can't be could. I'm all for having it be limited through the prism of the impact on the child, but the First Amendment comes at a price. It can't be could.
Let me direct Your Honor to two cases. One is Prince versus Massachusetts. I'm sure you all have read it, from 1944. And the case of a custody of a minor, which I believe, I don't have the site, but I believe it was decided by this court in 1975 or 79. When you read the dissent in Prince versus Massachusetts, what the dissent in that case highlights was that there was no evidence of any harm that was articulated in that case. What the dissent says in that case simply is that there was a possibility that harm might occur. Nevertheless, the Supreme Court determined that it was constitutionally permissible to impose a restraint on the mother's rights in that case to express herself, to express her religious views. There was no present harm. The second case, custody of a minor, if you recall, the child was a mere 3 days old. And after the DCF or DSS at that time filed a petition to remove the child from the mother's care, the court did so. And on appeal before this court, the mother made the exact same claim. There was no evidence of any harm to the child at that moment.
Can we start narrowing this a bit, because we're going to run out of time? So I take it both sides agree that having a child hear one of their parents disparage the other child is harmful, right? Is that right?
I believe that should be right. I believe that should be
And do
accurate.
both sides agree that there's a compelling interest in avoiding that, or is there disagreement about that? I'm just trying to understand. My sense of what you both agree on is that this is a prior, that these non-disparagements can be a prior restraint on speech, and they need to satisfy the strict scrutiny standard, compelling interest, and no less restrictive alternative. Is that correct?
I believe it is, Judge, although...
And the question is how far you can go. What is the least restrictive alternative? That seems to be what this case is about. Is that right?
Well, it's unclear to me, reading the brief, whether it is in fact undisputed that speaking in the presence of the child is something that is an appropriate restraint. I would say that it should be. I think, respectfully, as a matter of common sense, it should be.
I thought there's a lot of, I mean, maybe it wasn't presented properly in this case, but there's a lot of evidence out there that this hurts the kid if they're hearing their parent disparaging the other parent directly. Now, I don't know about indirectly and all that, but I'm just trying to narrow this, because you want us to provide guidance, and I take it where we really need to provide guidance is what is the least restrictive alternative that's permissible under the First Amendment. Is that right?
It is, Judge. And
What kind of evidence do you need of something like that? What kind of findings do you need?
Well, I think the findings that, to answer that question first, Your Honor, the findings that would be needed, trial judges, the decisions from this court highlight that trial court judges are entitled to enter orders that are not just remedial but are preventative. And as part of that analysis, this court has instructed the lower courts that they are to use their judgment and their experience and make their best reasonable prediction as to what might happen in the future, and then enter orders to prevent that harm from taking place. And in this instance, merely speaking the derogatory words, to Your Honor's point, Justice Kafka, merely speaking derogatory words is harmful to the child.
Know that.
I guess we know that the same way that we know that by respectfully hitting a child with a stick is bad. I think at this point, I think the studies that Your Honor, Justice Kafka, has highlighted
I may be jumping over a step, as Justice Link points out, because I'm not sure what this record is. The judge just sort of assumes that, and having read thousands of these cases, I would say, yeah, there's a bunch of evidence out there. I'm not sure it was put in this case, though. And do we need an evidentiary record here, or are we going to sort of do what the judge did, or can we pull it out from our other cases? And if so, which cases?
Well, what I would say in this case, and let me sort of frame the context that we were in front of the lower court judge. We were there on a complaint for contempt. And the standard on a complaint for contempt is very different than, and obviously, that what I'm here talking about with you all today. But the record, as you've all have reviewed the record, the record highlighted extraordinary or substantial red flags that highlighted that there was a train that was coming down the tracks that needed to be stopped imminently. And some of the...
Disparaging about what the father said. Just identify, please, what was so disparaging about what the father said? I don't really understand that. I was expecting much worse when I read, frankly, the texts.
Well, some of the postings that he was... First off, he was already violating the prior court's order, and I'm not here to contest or address that, but he had already violated the court's order. He had
Speaking at all.
I'm sorry?
By speaking at all, he violated the court's order.
Well, in particular, he violated the order by posting disparaging remarks,
That's what I say. What is disparaging about what he said?
referring to the mother of his child as an evil liar, as immoral, as cruel, as posting online, imploring others to defriend her, posting matters with members of her temple in order to ostensibly to isolate her from her social community. The record also contains...
Those are two different... We have to keep the child separate from the mother, right? There's a whole different set of interests about disparaging your spouse than disparaging your spouse in front of your child, right?
Yes,
Isn't that
Judge.
the first, most fundamental thing we need to keep separate?
It is.
And the judge doesn't really do that here, does he?
I think he does. I think he looks at the history of the case. He looks at the history of the facts that were before him, and he tried to draw a reasonable inference as to what was going on and what he needed to do to protect the child from the future.
But here's the thing. This is in the middle of a divorce, right? And the judge is going to make certain findings. The father can say things, and he can make himself look like a jerk, right? The father can be a jerk. And if he's a jerk, it's not going to count against him in connection with the custody proceedings.
Yes, Your Honor.
Okay. So why do we need a prior restraint if the same thing is going to happen?
So one thing that comes out of the record, one of the things that to answer the question a little bit more clear that hopefully frames it, following a visit, and this is in the record, following a visit or on the heels of a visit at which the child was present or in close proximity to hear, the father refers to the mother of his child as Hitler. Mother is a practicing Jew. The father had the opportunity to refute that, and he chose either not to do that or try to rationalize it. And that cuts to the quick of really what is going on here. To address your Honor directly, this is about the child. And when child hears that, now the child is presently 2 years old, but the child is growing up. And when the child hears those types of hurtful things, harmful, derogatory things about one of his parents, I believe it's a reasonable inference to infer that the child will then start to have either doubts or think negatively about himself, think negatively about his mom.
I mean, just back to Justice Lowy's point, I mean, we can't project this child's 2 years old, you know, it's not on the internet, I can't remember if it's a boy or a girl, but don't we need First Amendment's focused on imminency, it's focused on time, place, and manner. This is just sort of really amorphous, the way we're getting at this. And if we're creating a rule, we need to have some kind of rule that we're working from, as opposed to like all over the place.
So there are two cases that have been decided by this court having to do with First Amendment issues in custody cases. One I've cited in my brief, the Felton case, which was decided, I think it was around 1981. And the second, I'm embarrassed to say I missed. It's Kendall versus Kendall that speaks to the issue of religious freedom under the First Amendment. And I don't think that the analysis of that case falls so neatly, although it is under the First Amendment, it falls so neatly under these circumstances with the freedom of speech. And that is for the simple reason that the whole object that the trial court judge sought to prevent and protect was harmful speech to the child. And it's not something that you could wait to see if there's going to be an impact. In the Kendall case, there was some validity to, it might be beneficial to expose the child to alternate views of different religions. But I would say that there is no benefit at all to exposing or forcing a child to expose the child to hurtful speech being made about one of his parents. There is no benefit to that at all.
Well, except that, in Edith, Judge Wilkins clearly said a general rule that bars any parent from directly or indirectly revealing the names of children subject to a care and protection proceeding will not do. There must be evidence and findings as to what effect the disclosure of the names of the particular children will or might have on them, on the particular children.
Your Honor, I'm sorry, I didn't follow everything that you just said.
I'm sorry, I'm saying Justice Wilkins basically I was reading too quickly. Justice Wilkins was saying in Edith that you have to have particularized to a particular child as to what the harm is going to be. And you're basically saying that we always know in every case that saying anything derogatory in front of the child is going to be harmful to that child. How do we know that?
What I'm saying is something which I hope is fundamental and very basic, and that is it cannot be the law of the Commonwealth that any parent can unfetteredly disparage with impunity the parent of their child in the presence of their child. That can't be the law of the Commonwealth.
And so why doesn't that have to do with parenting time and supervision?
Well, that could be a natural consequence of
Consequence of your
that
actions.
happening, but it's even more basic than that, Your Honor. Let me refer the court to another case. Your Honor cited Justice Wilkins. But the case of petition of Department of Public Welfare to dispense with consent to adoption, I think frames the matter.
What was the date on that one? I'm not familiar
That
with
was
that one.
1981, Your Honor.
But that was before this case. Edith was 1995.
Okay, but I think the principles enunciated by this court in that case frames the matter before the court today very broad, very specifically, and it states, the paramount duty of courts is to protect children, and to that principle, every other public and private consideration must yield.
Including constitutional ones?
Where a child's well-being is placed in issue, as it is here, it is not the rights of the parents that are chiefly to be considered. The parents' rights will not be enforced to the detriment of the child. As far as the parents' fundamental rights, there are 3 cases that highlight that a trial court judge has the authority, I would say the duty, to exercise discretion to protect the child, even at the expense of a parent's fundamental and constitutional rights. Number 1, that would be visitation can be denied. Vilazaki versus Maxey, 1976. Number 2, the parent-child relationship can be severed entirely. That's the adoption of Willow case, I think, of this court of 2001. And last but not least are the 2 cases that I cited before, the Felton and the Kendall cases. A parent's freedom of religious expression under the First Amendment can be restricted if to do so satisfies and serves the child's best interests. What we're asking for here is nothing different than that. And where we have the authority, strike that, where we have the ability, and you have the power to exercise or impose an order that can prevent harm before it happens, I think we should do that.
Before we leave, no disparagement within 100 feet of the child? Are you claiming that that's something we should enforce?
It is, Your Honor. I think that if the child, depending upon the decibels that have been used to refer to the spouse or to the parent, I think 100 feet is appropriate.
So if the family is home for Hanukkah and Mr. Shak's brother or sister is there and he says, I want to speak privately to you, and they go into a room, he is barred from saying, my wife is driving me crazy because she's terribly unfair? He can't speak privately to his brother if they're at the same home and the child's in the home?
Under the order that you have before you, that would not fall under the order. That would not necessarily be disparaging.
It says, or anywhere. Oh, well, let's assume it's disparaging. He can't disparage, he can't speak to his brother and disparage his wife? If the child is in a different room?
If the child was in a position or in a place where he could overhear that, then that would be improper.
But it says within 100 feet of the child or anywhere if a child is in a position to hear, read, or see. So I assume that that's meant to be a separate and distinct requirement, or should we interpret it to say, essentially ignore the 100 feet and just say where a child is in a position to hear, read, or see?
Well, I would read it exactly the way it was.
Okay, but I mean, the problem is that doesn't the father get to kvetch to
Oh, God.
to rabbi or to people who are close to him, as long as the child, I mean, doesn't,
Sure he can, Your Honor.
so. but
He can do that so long.
Doesn't this arguably bar him from being able to do that even where the child, even when there's no reasonable likelihood the child will ever learn of it?
No, Your Honor. The order, I think, is very narrowly tailored, not only to content, not only to the scope, and we've talked about that for a minute, but also to the scope. He is free. He is not restrained from complaining or raising his concerns with anyone on the planet. He has not been constrained from sharing his disparaging remarks about mother directly to her. He is not restrained to do any of these things. So long as the child,
Under this order, of course he is.
so long as the child is not present to overhear it. He has not been censored. His views have not been stifled.
Okay, so the principle that you're espousing is, as I understand it, if there is he cannot disparage her where there is a reasonable likelihood that the child will hear it or learn of it. Is that the standard?
That is the standard, Your Honor. I think the trial court was trying to articulate that with the 100 feet.
Within 14 years, until the parties have no common children under the age of 14 years old, neither party shall post on any social media or other internet medium any disparagement of the other party. That's super broad. I mean, that's more than the chief's example of vetching in the other room. You can't post anything anywhere on the internet for the next 12 years that says something nasty about your spouse. That can't be legal, can it?
Your Honor, let me just say that there are three areas where he is precluded from posting on the internet, and 3 areas only. Disparaging remarks about her morality, disparaging remarks about her parenting, and disparaging remarks about her ability to parent. He can post anything he wants about how bad of a spouse she was.
Well, hold on a second. If he says she's a liar, she lied about me, that's her morality, right?
It is.
And if he posts that any time in the next 12 years, he's in violation of this order. If that's legal, I'm flabbergasted.
As it's written, it is. And I think the idea was designed to protect the child into the future using a reasonable estimate of what was needed in order to protect the child, given that the internet is forever. And as anyone here who has a child under the age of 15 knows, that if they have 5 minutes in a cell phone, they can find anything on the internet at any time. And what worse thing to find out on the internet of some bad things that your parents have said about the other? It causes you to question yourself. It causes you to question the judgment of your parent. And it could erode the relationship with the parent who posted it.
Isn't that just growing up?
I don't think it is, Judge. I don't think it is. I think that the courts we're not regulating children growing up. We're regulating a parent's ability to disparage and cause hurtful words to harm the child. That's it.
What could he say about the mother that would be okay?
I'm sorry, Your Honor?
What could he say about the mother that would be okay under the first paragraph?
She was a great mom.
Even though he thinks that's false. Even though he thinks that's false. You're telling him he can't say what he thinks is true.
He can say what he thinks is true. He just can't.
Terrible mother.
He can't post that on the internet for 14 years.
But he can't even say she's a great mom, right? Meaning with sarcasm. He can't say that either.
Well, I would say that under the order that it has been written, he can.
Okay, thank you.
Thank you, Your Honor.
Ms. Lamanna.
Good morning. May it please the court, I am Jennifer Lamanna, and I represent Ronnie Shak. As the court has indicated, non-disparagement orders are blatant violations of the First Amendment.
Well, I'm not sure that's the case. If we have father screaming that the mother is a lying blankety blank in front of the child, we can't put an order in place that says that's not proper, given all we know about the psychological effects of one parent, lambasting the other in front of the child. I mean, we can't, just that little order. You cannot, rant and rave about what a lousy parent someone is in front of the child.
What Your Honor's example
Is that
highlights
legal?
is, I think, the main point here, which is what you're saying is, if someone has done this, can we not issue an order saying you can't do it again?
Well, but we know that that's harmful to the child to hear, so we want, and also, we know the parents are doing that. All of us have read 5,000 divorce cases where they scream and rant about each other in front of the child, and the judge issues these orders to stop this because it's having a harmful effect.
I think
That narrow order, so basically every non-disparagement order that's been issued by the probate and family court for the last 20 years that includes that is illegal?
it's illegal if the court did not engage in what the Constitution requires, which is a specific, fact-based inquiry. Your Honor, I believe it was, Your Honor, Justice Kafka brought up the clear and present danger line of cases.
Right.
And that's where we get on this type of burden of speech. The words used have to be used in such circumstances and be of such a nature as to create a clear and present danger that they will bring about the substantive evil. And in Massachusetts, our cases have taken that term substantive evil, and the court has used the phrase instead, serious and identified threat of harm.
Suppose there were specific findings here that, as to this child, it is a very bad thing psychologically, emotionally for this child to hear his father say these terrible things about his mother in his presence. Could we say that in those instances, a non-disparagement order as to what the father may say in the presence of the child is appropriate?
If there were specific findings that he
Yes.
had done that, then yes, you could.
Okay.
And as Your Honor pointed out, you could also have there be consequences to his behavior. You could have his parenting time be supervised. He could have no contact at all if he demonstrated a continued inability to bring himself in line. But that's not what these orders do. These orders say he's not allowed to post on the internet. He's not allowed to complain, air his grievances, express himself on the internet to other adults because the child could. And Justice Lowy specifically identified how alarming the word could is. The word could has absolutely no place in a constitutional analysis regarding restrictions on the First Amendment. The harm must be serious and identified, and it must be imminent. So to say in this particular case, and these orders entered when this child was a year and a half old, to say someday he might go into his father's Facebook page, and he might look up what his father said. And I would respectfully suggest, as a side note, I'm sure you all carefully reviewed the record, my client didn't say anything disparaging. What he did was he highlighted everything disparaging she had said about him in court, in matters of public record, and denied them. The worst thing he said was that she was an evil liar, and you are told it constitutes disparagement because he asked his two brothers, and sister-in-law to unfriend her. That is what could be so damaging to this child somewhere within the next 14 years that my client's right to use the most common form of communication currently in use.
I agree with you that this seems overly broad. I'm trying to understand, though, the rule you think, because we've got a probate court that deals with this problem on a regular basis. So if there are specific findings that disparagement has had a harmful effect on the child, can you issue an order to do this? And if so, how should we draft such an order? Because we've got to provide guidance to the court as well as answer this particular case.
So I think part of the problem that there is in crafting these types of orders, and I agree with Justice Kafka that you see these all the time, but generally they're limited to neither party shall disparage the parent in front of the other, in front of the child. So you don't say the horrible things that you were suggesting could be said. You don't say things like that in front of the child. But to go to the next step and say, you can't write about it, you can't share your written thoughts.
Okay, so you're
with other
saying
adults.
that rule should be limited just to face-to-face contact?
I'm not saying that that's the only limitation that would be appropriate here, but I am saying that that at least is the specific, serious, and identified harm that a constitutional analysis requires.
Okay, but
Child's right there, the child hears it.
let me test it a little bit. Okay, so you've got a 10-year-old child with a telephone. Can you text about, I just met your mom, she's an evil liar, and can you do that to the child, the 10-year-old child?
No, Justice, and I addressed that in my brief, that I think that the way that the court could tighten this up is to say, for example, don't email disparaging things to your former spouse and CC the child or BCC the child. Don't put disparaging things on Facebook and tag the child. If you insist on using Facebook as your means of communicating with your broader community, then make sure you're not friends with the child on Facebook so that he's seeing all of your posts.
So is the rule, do not disparage your, again, this is assuming that it's had a harmful effect on the child already. Don't disparage the other parent in front of the child or in another time, place, or manner where the child's going to hear it, or what?
It's directed to the child.
So it
Because
has to
where
be-
the child is going to hear it opens up this enormous realm of,
So it has to be directed at the
it
child.
has to be directed at the child, because I think that's the clear and present danger that allows for this restriction on this fundamental right to freedom of expression.
Now, counsel, would you say, suppose we have a different fact pattern and we have disparaging remarks made on Facebook about the parent, and the child actually sees them and does actually get upset, and the other parent comes into court, probate court. What kind of order could they issue in those circumstances?
So
Would that be substantively different than your case?
it would be substantively different, certainly, because in this particular case, all of the affidavits, everything submitted by the mother was about her. This could harm me in my community. This could harm me professionally. None of which is relevant, because none of that is a compelling state interest to protect her. That affidavit, it's now become about the children, but that's not what this case was about. It was about the mother. But in the case that you indicate, that would be, what would generally happen in the probate and family court is you'd come forward, you'd offer your pleading and say, father posted that I am a whacked out junkie on Facebook, and our child read it. And our child was upset and said, what does this mean, et cetera, and now she's in therapy, for example. I would expect a probate and family court judge to say to that, would obviously view the post, would want evidence that the child had in fact read it, that the child had in fact been harmed by it, and then would issue orders accordingly. You shall not do this again. If you must post on Facebook, you should target specific people, or you should unfriend your child. People can do lots of different things to keep things private on the internet. You can create a fake profile and only let certain people know. I'm sorry.
What if the child's 14 years old and, an active user of social media, and the father creates a Facebook page or a Twitter account that says, "Mom is an evil liar"? Does that require protection?
Only if you can also fulfill the next prongs, which are, is the child upset by it? Does the child think it's funny? Does the child agree? I mean, that's one of the problems with all of this non-disparagement talk in the probate and family courts, is this fiction that children don't know what's going on. And that, as my brother was suggesting, that my client is only allowed to write, she's a great mom. She might not be a great mom. I'm not suggesting she isn't, but in many cases, she might not be. She might be a mom with a substance abuse problem or a mental health issue that the child is well aware of.
Well, the children probably always know more than we think they know, but unfortunately, there doesn't seem to be a limit on the creativity of parents and their willingness to use the children as weapons to manifest how much they hate each other. And there needs to be, some balance here. You can't, the First Amendment's not going to prohibit somebody going on the internet and defending himself or herself, but where's the line? If the communication is not directed toward the child, but common sense tells you that the child is going to end up digesting the junk, is a point where these disparagement orders might have a place?
I think there is a place for these orders. And always when we're dealing with direct communication to the child that is disparaging, harmful, and there's a direct link.
But what if what if the probate and family court judge, doing this all the time, just makes a determination that this means of communication is likely to get to the child and likely to harm the child, and that's the finding that's made, but it's not directed directly to the child.
So Your Honor is suggesting that there are specific facts that are advanced at that hearing that indicate that likelihood, that the court can rely upon. Right. I think, again, when you have specific facts indicating that, that brings you back to this direct link. The problem is this, is that would anyone suggest that my client could not write a book about his struggles in the probate and family court? Could he not write a book about this and publish it? Could Ms. Shak go into court and prevent him from publishing that book because the child might read it someday? I would respectfully suggest that that is not the case. She could not do that. So one of the things, and there's case law up at the Supreme Court level where they talk about in the context of kids having access to pornography, where they say we should not assume that parents are not going to put appropriate limits in place. We should not assume that fully informed parents will not take action. So in this particular case, not my specific facts, but in the example that we're using, if you have someone who's posting on Facebook and you have a particularly tech-savvy child, I think they all are these days, it seems, who's able to find anything on the internet, what is the parent's role in that? Is it the court's role to limit the posting parent's First Amendment rights, or does it become a parental responsibility to say, look, there are things out there I don't want you to see? Because I think that's something as parents we do all the time. There are things we don't want our children to see on the internet. I don't want you to be friends with your dad and his new wife and their friends on Facebook because your dad and I had a really ugly divorce, and there are things there that you don't need to hear in that forum. So one of the things I'm going to do as your parent is I'm going to check your friend list, and I'm going to see who it is you're accessing. And if maybe the dad in this scenario keeps posting terrible things, maybe I have to go into probate and family court and say, Judge, I've asked him twice, but he is still making these things public, and he's not willing to limit them so our 14-year-old child doesn't see them. These are all steps after the fact, which is exactly what the Constitution requires. That after the fact, defamation, things like that, it's after someone has acted.
Because words have consequences. Words have consequences.
Exactly. Words have consequences, and there are legal consequences, sometimes civil, sometimes criminal.
Can I
But
ask
that's
you,
what's
are you
appropriate.
saying that you can never do this purely prophylactically, or that, or you have to have an instance where it's been done first? Is that the kind of evidence you're looking for?
I would say,
He did
so
it.
the reality of the situation is that people routinely, willingly enter into these agreements because nobody wants the other person doing that to them. So you very often see neither parent shall make disparaging remarks about the other parent to the child.
In any forum.
I mean, that's just a standard throwaway temporary order stipulation that gets entered all the time.
Yeah.
What happened here was
And
the mother came in.
that's different, right?
Pardon?
If that's different, right? That can't be unconstitutional to enforce a voluntary agreement. That's
agree.
different from the court imposing that on.
That's right. That's right. And that's the Nash case that my brother cites to, where it says, the court says, we can do this. These people entered into a stipulation that said that they wouldn't do that. My client didn't enter into that stipulation here. So to answer your question, Justice Lang, can it ever be done prophylactically? I would suggest that if it were going to be done prophylactically, it requires more of that fact-finding that we've discussed. You can't just come in and say, I need this order because it might happen. Because not every person who comes before the court is going to behave that way. And the problem also is, what is disparaging? Is it disparaging to say someone who has accused you of being a cocaine-using, cat bone-breaking, horrible person in probate court filings? Is it disparaging for my client to say, this is what she said I did, she's a liar? Is that him disparaging her and she deserves the protection of the court and he deserves restriction? Because what we keep coming back to in this, I can't get away from it in terms of my thought process here, is that this is a matter of public record. And that means the legislature has analyzed this and said, look, there are some cases, juvenile court cases, we want that to be private. We want it to be impounded. That has not been the case in probate and family court matters. So when people air their dirty laundry in public filings, it's pretty difficult to say that one of those parties, or both of them, can now be restricted from taking what is already.
But the problem is, it's the kid.
Right.
The issue is not I'm totally with you until you get to the child.
Sure.
You can say what you want about your spouse, tough luck, but it's when it's in front of the child, we got to have a rule. Back to Justice Lowy's distinction, which I'm trying to understand where you ended up. So you said directed. Then he posed reasonably likely to get to the child. If it's reasonably likely to get to the child, is that the better standard than directed?
Well, reasonably likely, I imagine that could be very broad
By the
depending
way,
on.
is that a First Amendment standard? I mean, we got 1 million First Amendment cases, but there are not that many cited in the briefs in the divorce context. I mean, I read all the ones you cited, and none of them give us a very good rule.
They don't. They don't. I agree, because they're dealing with these larger issues of pornography and adult access and the press, which is obviously much broader than these two people and their child. But using Justice Lowy's phrase of reasonably likely, if you could demonstrate that it is reasonably likely that the child is going to have access, and also you have to establish that you can't get away from the fact that there must be that serious and identified harm. So it not only has to be reasonably likely that the child is going to learn of it, it also has to be apparent from the record, I believe, that harm will result. If you have those two elements, the probate and family court could certainly craft a narrowly tailored,
Does that mean with a
fact-specific
two-year-old
order.
child, you can never put this order in place because the child doesn't know what you're saying?
I think the burden,
Well, I
if you
guess
were
a
the person
two-year-old-
seeking it, your
two-year-old
burden
can-
would be high. Because again, it's also speculative. The child could see it someday. It might still be up there. And people keep talking, there's all this discussion about how the internet is in perpetuity. Is it? I think the average person doesn't know how to access their 10-year-old Facebook posts. Are they still out there? I don't even know. Will they be out there 10 years from now? It's all speculative. So, and again, the older the child gets, the more time that has passed, I would respectfully suggest, the less likely the child is to be harmed. 10 years from now, this child will be well aware his parents went through an ugly divorce. Will it be that damaging to read, my mother accused my father of this and he said he didn't do it? So
So you say there must be proof of serious identified harm. How are you supposed to prove that?
So the serious and identified threat of harm and I'm quoting that from Prescott Publishing and Stoughton, so a specific Massachusetts case that talked about this prior restraint issue. How do you do that in the case of probate and family court? So as I mentioned earlier, I don't believe that every comment that could be considered disparaging is necessarily harmful for a child to hear. It has to be serious, and it has to be identified, and the harm must be real. There could be a number of different ways that could be presented. Sometimes the language itself will be so obvious. It will be so inflammatory, so disgusting, not in our case, but that it's clear to anyone that no child reading this could be anything but harmed to hear that about a parent, even if the child agreed with it because the child's allied with the parent who's posting this nonsense. So, but when you wander down the road of, she's driving me crazy, this is all about the money for her, those types of remarks. You know, that's what child support is for. Your mother keeps asking me for money. I pay $800 a week in child support. Remarks like that thrust the children into the middle. The analysis becomes more fact-specific and more child-specific. There are plenty of children out there who are intelligent enough to know this is just how my parents are. They've been doing this for years. Now they're finally doing it in a courtroom and other people are seeing it. So I think that the way that you demonstrate that serious and identified harm is you actually identify it, and you link it to the words, and you link it to the specific child involved. And when you do that, you are entitled to an order that will protect that child, and you are not going to run afoul of the Constitution. But if-
Can I ask then?
Certainly.
Is the language itself then too vague? Is non-disparagement itself too vague to survive a constitutional challenge in your view because of that?
Yes, I think it is. I think it is, because particularly if I just take this case, and I see what this judge decided constituted my client disparaging Mrs. Shak, I find it extremely troubling. Justice Link asked, what did he say that disparaged her? He called her a liar? Is that disparaging in normal adult discourse? People call each other liars all the time. He said, she accused me of this, I didn't do it. That's what every responsive pleading is for, is you've accused me of this, I'm denying it.
Did the judge actually find that these are disparaging remarks?
He wrote, and actually in one section of his memorandum, he wrote that he credits her testimony that this could harm her in her community. He credits her testimony that this might hurt her professionally, and he says it might even rise to the level of defamation, he says.
Right. But I'm saying that the disparaging remarks about the child, in front of the child. I mean,
He did not make that finding. He did not make that finding.
No.
And that, without that, and again, I mean, that you were told today that my client allegedly made a comment and called her Hitler in front of, then my client hasn't seen his child in a year at this point. So Ezra was about 18 months old. Does Ezra know what that means? Was he upset by it? I mean, that's obviously, it's nothing but a pejorative remark. But can you link that to harm to the child? And isn't that a very simple targeted thing? You shall not identify your spouse by the name of a horrible dictator?
Yeah, but if you do that, then that permits a bit of variation to avoid a contempt finding. I mean, yeah, so he'll call him Mussolini in the future, or Stalin. That's not likely to be an effective way to enforce what you're saying we can enforce.
No, I'm not suggesting that. I mean, the probate and family court here gave a long list of
Right, I understand
seven
that,
dirty words that my
none of which
client
were
didn't use,
alleged to
but-
be used. But, so you say it must be more than disparagement, so what must it be?
It must be directly harmful for the child to hear.
And how is a judge supposed to prove that it's directly harmful?
Well, I don't think the judge has to prove it. I think that the parties
Or
have
how
to
is a
come-
judge to make a finding that it's directly harmful? What proof must a party make in order to show it's directly harmful?
Evidence that the child heard it, that the child was upset by it, and perhaps continues to be at the time that the parties come forward. There are certainly things that are said in a household before divorce is filed that children hear, and it's, what happens? What do parents do? They console their children. I did call your father that, and I shouldn't have said it. I was really angry.
So, but that goes back to Justice Lang's question, where you said, well, you don't have to wait for the harm to happen before you impose this order. Are you changing that point of view, or do you?
I'm not changing that point of view. What I'm suggesting is that I was linking that to what the judge is doing. So if you're coming before the court saying, I need an order preventing this from happening, you need to be able to demonstrate that this is not a harm I can address on my own as a parent. So I can't protect my child from this language by limiting his Facebook use. I can't protect my child from this because his father insists on saying these things during every visit. That's a situation where you are demonstrating to the court, now we have tried to resolve this, I have tried to protect my child, I now need the court's intervention, and I need a limitation on this person's freedom of expression, and I can tell you exactly why I need it and how broad it needs to be. I think that that's the type of guidance the court needs and is required before the court can issue orders burdening freedom of expression in this way.
On the other hand, the same expression could be, have consequences that are very negative to the parent who's making those comments.
Absolutely. This happens all the time. I mean, that's really where these things should be resolved, it's almost routine at this point in probate and family court matters for the trial judge to appoint a guardian ad litem to conduct an analysis. And one of the things that that person is doing is talking to the child about what they know or understand of the family's conflict, looking at whatever materials either party wants to present. This is what he's posting about me on Facebook. This is what he texted our 12-year-old daughter. Things like that.
This is what he said in front of her.
Yes, and this is what he said in front of her. This is what my children are reporting when they come back from a visit. Dad says you're taking all the money, or things like that. And then, absolutely, Justice, that's when consequences come into play. We can't trust you, sir or ma'am, not to expose your child to this damaging language. And so this is the consequence that we're putting in place. I think that's appropriate.
Okay, thank you.
Thank you very much.
And we'll take our morning break.